Welcome to the Law Council of Australia's online event, Indigenous Incarceration in the Northern Territory, Progress Made Since the Royal Commission into the Detention and Protection of Children in the Northern Territory. My name's Pauline Wright and I'm the current President of the Law Council and the moderator of this event. Without further ado, I'm delighted to introduce Ms. Mililma May to provide the welcome to country. Mililma is a Larrakia and Tiwi woman from the Northern Territory. She's studying law at Charles Darwin University and is the first recipient of a joint legal cadetship between the North Australian Aboriginal Justice Agency, NAJA, where she works as a community legal educator, and Gilbert and Tobin. In her role, Mililma has been leading the legal education crew in Don Dale and has more recently been developing resources to empower and educate the young men and women in the detention centre. Mililma is also a co-founder of UP, Uprising of the People, a grassroots not-for-profit organisation that fights for the rights, healing and sovereignty of Aboriginal and Torres Strait Islander people in Darwin. Mililma.
Good evening. My name is Mililma May, and I'm here to welcome us to this event. Welcome to countries are an ancient protocol of respect where visitors to a land are provided with permission and acceptance onto a land that is not their own by people whose land it is. In tonight's setting in this virtual space, I do not feel it is completely appropriate for me to welcome everybody to everybody's country. I will welcome us all into a frame of mind that we can choose to share for this panel. I am entering this space as a Larrakia woman. I am Larrakia through my father, through his mother, and through her mother before her. As Larrakia, we hold affinity and spiritual connections to the land where Darwin now sits. Place, land, and connection are crucial to us as Larrakia. These elements connect us to our identity, our history, and our communities. To know the land you stand on, to know whose land you stand on, is the beginning of healing our nation. This seemingly simple piece of information establishes and reaffirms the existence and survival of Aboriginal and Torres Strait Islander peoples across the continent. By acknowledging Aboriginal land, by acknowledging Larrakia land, together we are paying attention and paying respect to a sacred element of every Indigenous person's existence. Our land is us and we are the land. We are one and the same. Like the land, we experience the blazing sun, thundering skies, and crashing tides. Together we feel the dehydration of drought and the burn of flames. We as sacred peoples to this land feel every act of injustice or harm done onto us or around us. Yet, like the deciduous banyan tree, there comes a time after our leaves have fallen that a new growth appears. We the people, like the banyan tree, when solid in our roots, when connected to the intricate ecosystems around us, can form new arms and extend further. We can become the sanctuary, the place to cool off, the place to simply sit and be. This new growth is a manifestation of years of struggle, years of sacrifice, years of fight, and most of all, years of nurturing. This panel this evening is a continuation of that long journey. Together, we enter this space following our ancient protocol of respect.
Thank you very much, Mililma, for that heartfelt welcome to country and for showing us through your words, but also through your work, the great strength and intelligence of young people advocating for social justice today. I acknowledge the Ngunnawal people, who are the traditional custodians of the land on which the Law Council Secretariat is situated, and pay my respects to elders past and present. I extend this respect to the traditional custodians of all the lands from which attendees dial in to be with us this evening, and to all Aboriginal and Torres Strait Islander peoples and elders in attendance. I'd also like to extend my warm welcome to all attendees to this webinar today. The Law Council's honoured to present a panel discussion this evening with renowned advocates and leaders in their fields, Mr. Mick Gooda, Ms. Olga Havnen and Mr. David Woodruff. No doubt their biographies could fill pages, but in the interests of time, I'll provide only a short introduction to each of them. Firstly, Mick Gooda has spent the last 30 years advocating for the rights of First Nations Australians through many high-profile positions. He was appointed the Aboriginal and Torres Strait Islander Social Justice Commissioner from 2010 till 2016, when he was appointed co-commissioner on the Royal Commission that we're discussing today. Of course, Olga Havnen is a prominent Aboriginal leader, advocate and activist in the Northern Territory. She's currently the CEO of the Danila-Dilba Health Service in Darwin. She's held many other significant positions, including with the Australian Red Cross, the Northern Territory Government, the Fred Hollows Foundation and the National Indigenous Working Group. And finally, David Woodruff. David is the Principal Legal Officer for NAJA, with over 20 years' experience in criminal law and management of the Northern Territory's largest legal practice. He's also the president of the Aboriginal Lawyers Association of the Northern Territory, Winkuku Rumbabanji. We're here this evening to examine the progress made since the Royal Commission into the detention and protection of children in the Northern Territory. It was formed to inquire into the failings of the Northern Territory's youth detention and child protection systems from 1 August 2006. We'll all remember the chilling footage aired on the ABC Four Corners program, showing abuses of children at the Alice Springs and Dondale youth detention centres in the Northern Territory. In handing down its final report in November 2017, the Royal Commission found shocking and systemic failures, which occurred over many years and which were known and ignored at the highest levels. The final report included 147 findings and makes 227 recommendations, too many to describe them all. However, in relation to detention, it found that youth detention centres were not fit for accommodating, let alone rehabilitating children and young people. It found an overemphasis on arresting young people, despite the principle that this should be a last resort. And of course, more arrests ultimately mean more youth detention. Far too many detained young people were there on remand, and therapeutic and diversionary options were sadly lacking. The Commission found that the child protection system was also in crisis. There was a lack of effective early support and intervention to support children and their families. The removal of children had frequently led to worse, not better, outcomes. The transition from the care and protection system to the criminal justice system was far too common. A lack of meaningful engagement with Aboriginal communities was fueling those policy failures. More attention was also needed regarding the underlying drivers that cause children to come into contact with these systems. And the Royal Commission's recommendations included closing the Dondale Youth Detention Centre and High Security Unit and replacing it with a new purpose-built facility. It recommended raising the age of criminal responsibility to 12, with no child under 14 years to be detained except as approved by the President of the proposed new Children's Court for a child who's been convicted of serious violent crime and still poses a serious risk. Developing a 10-year generational strategy for families and children to address child protection and prevention of harm to children. Establishing a network of family support centres to provide place-based services to families. A paradigm shift in youth justice to increase diversion and therapeutic approaches instead of punitive ones. Developing a new model of bail and secure detention accommodation, increasing engagement with and involvement of Aboriginal organisations in child protection, youth justice and detention. Our aim this evening is to discuss what happened next. So in terms of tonight's process, I'll put a number of questions to the panellists And if there's time at the end, we also hope to include some questions from you in the audience. And we invite you to submit questions using the Q&A function. You can access that function by clicking on the picture of the speech bubble, which should appear when you run your mouse over the bottom of your screen. You can then type your questions to the moderators, and hopefully we'll get to at least some of those questions.
Mm-hmm.
So starting with our questions to the panelists, and I'll put this to, firstly to David Woodruff and Olga Havnen. What progress has been made in implementing the recommendations of the Royal Commission into the detention and protection of children in the Northern Territory? And what do the data and research tell us about the outcomes achieved so far? David?
Okay. Thank you, Pauline. And firstly, I do wish to also acknowledge the traditional owners of all lands that we meet today, and elders past, present and emerging. I do think that we need to acknowledge that there has been some progress. There's been some progress in actually the reduction in the overall number of children who have been in detention by about 50%. And that has been led by the introduction of programs and support services, and particularly led by us Aboriginal sister organisations through Aboriginal Medical Services. So there has been that progress. There also has been some reduction in relation to the overall numbers of arrests, coming down from about 750 to 755 in 2019 to from 870. So there has been some progress there. Also importantly, there's been progress in the appointment of a dedicated youth judge for Alice Springs in Central Australia. So there have been some practical benefits that have been incurred. Some of the key recommendations, those transformational recommendations of the Royal Commission, are yet to be implemented. Clearly, the most important is about raising the age of minimum criminal responsibility, keeping children out of detention under the age of 14, transforming and making arrest as an option of last resort, but also providing all of the services and addressing the issues around children and being focused in relation to the child being centred in that. What not just the data and the research shows is that it is still the situation in Northern Territory for Aboriginal children is still grossly overrepresented in our youth detention systems. We know from the data that Aboriginal children for a very long period of time have been an incarceration rate of 100%, falling at the most to 97%. So what we do see from the data and the research is the overrepresentation of Aboriginal children, and not just in ending in detention, but starting right at the beginning in relation to their arrest, the treatment in custody, being held in police custody, coming before the courts, less access to diversion programs, ending up on remand and detention. I think there's not just the data and research, but I think we can also show that there's been practice now, that we have practices led by Aboriginal organisations and communities and supports to bring about change. That also reveals that the Northern Territory is in a great position to take the learnings that we have done so far in the partnership with Aboriginal organisations and Aboriginal communities and peoples to work to change our justice system. And the Northern Territory is in a great space to take a leadership role for the nation in changing the way that we deal with children and improving the situation for Aboriginal children across the country.
Thanks very much, David. Olga Havnen, do you have any observations on that?
Thanks, Pauline. Look, I think I'd probably agree that there are some minor and incremental changes that have been made over the last 4 years. And I'd agree with David about the fact that we're seeing perhaps, smaller numbers of young people in Don Dale, which is a good thing. However, what I would say is that I don't think that we've seen the substantive or systemic changes that we would have hoped to have seen in place within this last 4-year period. As far as I can see, I think, in the beginning there was major reform, there was significant amendments that were made to the Youth Justice Act, The government then subsequently made retrospective amendments back in March of 2019, and that I think has fundamentally undermined the reform agenda. We still don't have a single act that deals with both child protection and youth justice. And the fact that the government then committed to spend $20 million on a new youth detention centre right smack bang alongside the adult prison, completely, in opposition to the things that were recommended by the Royal Commission, I find somewhat staggering. Basically, we still have a corrections punitive model, and we certainly don't have a therapeutic model of approach to kids in care. I think the point I would like to make is that so many of these young people that are in Don Dale today, or even in the Alice Springs Detention Centre, come from the child protection system. It seems to me that there are two systems that have fundamentally failed these children, and there seems to be very little effort on the part of government to do anything, I think, in a meaningful way to remedy that. So I'm still pretty cross and upset.
Yep. Thank you very much, Olga Havnen. Mick Gooda, did you have any comments that you'd like to make in addition to those?
I think reinforcing what Olga said about the systemic change, and David raised it about raising the age of criminal responsibility. You know, we thought, like, the government committed to that on the day we handed our report out. We had a function in Parliament House and we didn't expect any commitments, but they did. And a couple of weeks ago, we had that great advocacy about raising the age across Australia. It would have been great if Northern Territory had have done that. Then we could have pointed to a place where it's in place and you know, it leads the rest of Australia. But what we've got is just down to the lowest common denominator, and we still can't get across to people that children who attend should not be arrested. Children who are, you know, there's states in Europe that have now raised the age of criminal responsibility to 16. And, you know, when David talks about the number of arrests and all that, imagine how it would be if we just raised the age of to 12. And the recommendation also said that would be the first step and you should raise it to 14 down the track a bit. But to me, that systemic stuff is so disappointing, as is the issue of rebuilding Don Dale almost where it was. You know, we obviously recommend a therapeutic approach, but again, we're not seeing that in place in any form whatsoever.
Thanks. I might stick with you for the moment, Mick, but I'm going to put the same question to all three of you. What still needs to be done to improve outcomes relating to incarceration of First Nations children in the Northern Territory? Well, in other words, what are the most critical priorities, including to avoid backsliding?
Look, I've been preaching this, same as Olga, same as David, same as advocates around Australia. You've got to actually listen and engage with the Aboriginal community. We're the ones who would benefit the most from this, because our children wouldn't be, first of all, going into child protection and then crossing over into the criminal justice system. But every time we made a comment at the beginning of the report in one of the early chapters about how everyone talks about resetting this relationship, and I don't know how many times I've been through a resetting of this relationship, only to be promised something else come election time or come an event like a Royal Commission happening. And we just got to get serious about listening and to Aboriginal and Torres Strait Islander people, and that was the whole basis of those things you mentioned about family support centres, about early intervention. So it was really important that for me, the more you listen to our mob, the better the answers are going to be. And look, there are good places around Australia where that's happening. I lived in Redfern during my time at the Human Rights Commission. By the police working with the community, dropped street crime by 80%. So we know what's possible if people have the will.
Thank you. Olga Havnen, in your view, what are the most critical priorities?
It has to be a fundamental reform and rethink about how we deal with young people who come into contact with the justice system. And by that I mean a genuine therapeutic approach. It is something that the language is so easily used, but very rarely implemented. The reason why I argue so strongly for that kind of approach is that if you look at the Banksia Hill study done by the Telethon Institute, it showed very clearly that there was a high prevalence of neurodisability amongst those young people in detention, well over 80% of the kids. So we're talking about kids with disabilities. Quite often it's that disability and impaired development that leads children to come into contact with the justice system. It would make much more sense to have comprehensive assessments, to work with that child and their family or their carers and get them the kind of supports that they need so that they can adapt and modify and change their behaviours. I suspect that a lot of these children too are probably likely to have FASD, fetal alcohol spectrum disorder. This is a lifelong disability. So incarcerating children in youth detention facilities and punishing them and not providing those services to them, I would argue actually further enhances their marginalisation and, you know, makes them less likely to succeed in society generally. I think that there's also a real cultural bias in Australia about not being prepared to look at other alternative models about law reform, more effective, if you like, and cheaper alternatives. And in particular, I draw your attention to the Spanish model of youth detention, known as Diagrama. Diagrama is a not-for-profit organisation. It manages about 70% of all youth detention facilities in Spain. It is significantly cheaper, but more importantly, it delivers far better outcomes. On average, they say less than 20% of their young people re-offend within a 3-year period. This is in complete contrast to what we do here. I would argue or suggest that we probably have 80% recidivism rates within less than 12 months. So for the life of me, I don't understand why, you know, government and politicians and the bureaucrats don't look more seriously at some of these better alternatives.
So they're cheaper and they work.
Indeed, like hallelujah.
Okay. David Woodruff, from your perspective at NAJA, what are your priorities? Do you agree with what Mick and Olga have said?
Absolutely endorse what they've just spoken about and wholeheartedly agree. I suppose from my perspective in the justice sort of space, it really is, we need to have a justice system that meets the needs of Aboriginal children wherever they live. Far too long we have a two-tier justice system where Aboriginal children in remote communities and the like don't have access to those program supports and addressing the needs in the community. So fundamentally, that is one of the key things. We need to have a justice system that meets the needs of children and their families wherever they are, rather than ending up in the system, in the justice system and in detention before those needs are finally addressed, sometimes. So we really need to have a system that is centred around children and Aboriginal children wherever they are. I think what is lacking is that there needs to be, and learnings from the Royal Commission is around accountability. We need an Aboriginal Children's Commissioner as there is in Victoria. It is providing that accountability that really provides the oversight and the protection of children, not just in detention, but in our child protection systems. Those would be the two other additional issues I think should be priorities.
Thank you very much. Thank you. Well, that leads us on to a related issue, the expectation in the Northern Territory, as in lots of other jurisdictions, communities are concerned with law and order issues and notions of youth crime and the need to combat youth crime. How do we address those concerns but still implement the Royal Commission's recommendations and ensure that a therapeutic approach is taken to children? So how do we assure the community that these alternative approaches are going to work to keep them safe, but at the same time providing proper rehabilitation and supports for young people who cross paths with the justice issues?
Pauline, it's patently obvious that what we're doing right now isn't working. And I've been, like David and Olga, advocates for this, doing this for years. And I talk about how we create safer communities. And we create safer communities by, one, preventing offending in the first place, and two, doing what David and Olga just spoke about reducing reoffending. That's how we create safer communities. And I tell people, if you think incarceration creates safer communities, just have a look at America, who incarcerates more people than anyone else in the world, and going by their like they got the biggest prison. I think 3% of the population in the world, 25% of prisoners in America. If you follow that logic, America should be the safest place on earth. But we know it's not. It's probably one of the most unsafest places. So I think we've got to, you've got to get the politicians to prevent this law and order auction. We're seeing it already, or it's already been a feature of the Northern Territory election campaign. How do we actually get the message across that you can't arrest your way out of this stuff? You've actually got to do what the evidence tells you. We relied on the evidence at the Royal Commission. We put it out there, but you know, some people just prefer to go with the anecdotes about how you fix this problem.
Thanks. Thank you very much. Olga, what are your observations about that?
Well, I guess my response to this sort of constant electoral beat up and law and order issues, you know, and as Mick says, you know, a law and order auction, I think if people had a look at the data and the facts, you'd see that, in fact, you know, communities today are safer than they've ever been. Far fewer people being arrested, particularly serious crime. I also wonder why it is that the police feel compelled to issue media releases every time there's some sort of minor incident that happens in the street or there's a break and enter. I think that feeds into the sense or the perception in the community that, you know, communities aren't safe. With respect to the beat up also about a focus on children, I don't tend to hear the same sort of shrill outrage about law and order issue when it comes to adults. So why is it that as a society and within the media that we think that children are the ones to be feared? The kind of offending that most young people commit, sure, you know, you don't want to have your house broken into, you don't want your car, you know, stolen and burnt or whatever it is that kids do these days. But it's no different to the way, I suppose, in which young people test boundaries, act impulsively, do a whole lot of other things. And there's a really good piece of work that was done by Justice Beecroft from New Zealand around, you know, the nature of youth offending. And he very clearly says that, you know, the trajectory of youth offending tends to taper off once these young people sort of engage in school, into work, and enter into relationships. And I guarantee you could go to any barbecue, you know, in any suburb of Australia on a weekend, stand around and talk to a bunch of blokes and ask them, what did you do when you were a kid or a teenager? What did you get away with? You know, the stories would be pretty familiar. So I think, you know, people need to take a bit of a reality check on what really is going on. For those young people who are committing serious offences, and now I'm talking about sexual assault and physical harm to other people, then I think that's deeply disturbing. And those young people actually need, I think, very intensive therapeutic and rehabilitation type programs. That's not happening at the moment. So by incarcerating these young children, all you're doing is actually becoming a feeder into the adult prison. And ultimately, you're not making those young people any safer to have in the community. So it seems to me that I think the media needs to be better informed. We need to have a debate that's informed by, you know, accurate and reliable data, but also about the evidence of actually what happens and what works.
Thanks very much. I mean, I note, Olga, that you know, data from 2016-17 shows that Aboriginal people in the Northern Territory were proceeded against by police at a rate 10 times more than that of non-Aboriginal people. And in the same period, Aboriginal people were taken into police custody in 75% of proceedings, while non-Aboriginal people are in only 57% of proceedings. So there's a different approach to...
A different approach, and to not put too fine a point on it, I mean, I think it's a good example of what I would call systemic racism.
Yeah.
You know, and I think we need to get real as a country to have that discussion as well, you know, the impact of racism.
Thank you. David Woodruff, what are your comments and observations about that?
I think there's another issue as well, is that there's another voice out there that doesn't generally get heard, and that's the voice of Aboriginal people and Aboriginal communities. And this was consistent during the time of the Royal Commission and subsequently, and that is the voice about the concerns about the safety and the well-being of their children ending up in detention. We need to listen to that voice as well. We also need to remind ourselves about the Royal Commission and what it exposed, and where constant campaigns around law and order, where it led to. And it led to a very dark place in the Northern Territory, where children were harmed, were traumatised, were brutalised by a justice system. Children kept in isolation. So we need to recognise where these discussions can go. But as Mick also said, we also need to be thinking about how we discuss these issues around law and order. Law and order can also be about how do we support children. How do we support children in discussions around their offending? Victim offender conferencing, working to solve these sort of issues. Having the privilege to participate in those sort of discussions in conferencing, and actually getting to understand a child's situation or family situation. I think that's the biggest issue, is that we don't have this communication. Once there is that communication, once there is that education, you know, you have that great insight, and then that's the way to tackle the law and order issue. But it's definitely, we need to be hearing the voices of victims, but also the voices of families and children, and the voices of Aboriginal people.
It seems to me that there is a greater alignment between the concerns of the community for law and order and the aims of therapeutic treatment of people in detention than is commonly thought. If we really want to reduce reoffending and recidivism and imprisonment rates, then the therapeutic model is, in that sense, a no-brainer.
I think if I could just add something there, Pauline, and that is that in, I think, 2018-19, on available data, it suggests that 74% of the young people who participated in a youth justice conference did not offend within that 12-month period. So, you know, here is an effective alternative approach. You don't need to lock kids up in order to change their behaviour.
Yeah. Indeed, it seems to, as you've said, the diagramma example shows that kind of treatment really does work. It's really effective in changing behaviours and stopping recidivism. So there is an example in the world that has shown to be working very well. All right, now we've got a couple of pre-recorded video questions. First of all, Tanya Collins, General Counsel of NAJA, has a video question.
Hi, my name is Tanya Collins. I'm General Counsel here for NAJA in Central Australia. I have been a lawyer here for the last 14 years, and one of the hardest parts of my job has been knowing that a lot of my young clients get remanded in detention and end up being taken 1,500 kilometres away to Darwin and Don Dale. My question to the panel is this: what can be done to ensure that young people from Central Australia are not separated from their family, culture and country when they end up in detention?
So who would like to go first with that answer? David, would you like to respond?
Yes.
To Tanya?
Tanya raises a very difficult issue and a real major concern. There has been the failure of implementing this recommendation around the transfer of children between detention facilities. As recently as June 2020, the NT Children's Commissioner, in her report, found that of 19 children in detention, only 15 children had no direct family contact. It's an incredibly important issue. One of the main sort of issues really is what to transform that situation is to providing the supports for families. We need families to be able to have those supports to visit their children, to be part of their development, but also part of the programs within prison. We also need to have an Aboriginal focused detention system, embedding Aboriginal practice, embedding support workers, Aboriginal support workers, people from their communities as part of that, and particularly around elders visiting into detention facilities. So there's some of the solutions to that issue.
Thank you very much. Olga?
I think I'd like to see greater support, particularly for families, to help kids comply with their bail conditions. That would be the first thing. The second thing I think is that, having a successful supported bail accommodation facility for those young people who may not be able to be properly supported by family for whatever reason. And the other thing is, why do we need to incarcerate kids when in fact they're being charged, they're on remand? So, this notion that somehow, these kids are unsafe to be left in the community when they haven't been convicted of an offence seems to me to be fundamentally wrong. Where's the presumption of innocence from my perspective? It's just a completely ridiculous thing that's happening with this transfer of kids from Alice Springs to Don Dale. I mean, they're isolated from family, from community, from culture. Quite often they don't have English as a first language. It's also been a source of conflict at Don Dale, where you've had kids from Central Australia in the same facility as kids from across the top end. So moving children from Alice Springs to Darwin is not a solution as far as I can see.
Thanks very much. Mick Gooda.
I think what we looked at the Royal Commission, particularly around bail, is, you've got to understand, Margaret White kept reminding me one of the main considerations of bail is whether the person will turn up for the next hearing.
Where else are they going to go, Mick?
Exactly. That's what I mean. If we applied that as a consideration, it would be a no-brainer to put...
We know where to find them.
Yeah, they're not sort of jumping on a plane and going overseas. So that's the first consideration. Then there's a consideration of community safety, and that and it's a phenomenon around Australia. David would know this and full well, how the police overload people with charges. So they come up before a magistrate, there might be 35 charges, and the magistrate will think this is a really awful child or adult, so I've got to put, for the community safety thing, put them, lock them up, and then come trial, they might be down to about 4 charges. It's a phenomenon with police around Australia that they overcharge. The other thing I think you can actually do really simply is create smaller facilities locally, so people don't have, if they're being held in remand, just put them in a small facility locally, because the evidence we heard about prisons, there's actually, the bigger prisons become, the more expensive they are to operate per head of population. It's not a usual economies of scale thing when you build prisons. So the idea is to build smaller facilities, and they're cheaper to run, they're closer to the community, and you won't be having kids transported all over the Northern Territory from places like Alice Springs to Darwin. And I've got to say, one of the most compelling pieces of evidence that we heard was one day when Dylan Voller got transported from Alice Springs to Darwin in the back of a police van, and he had to go to the toilet in his shirt and throw it out the window because they didn't stop for him to go to a toilet. Now, I don't know how you get from Alice Springs to Tennant Creek without doing that, and that's just, for me, it was just said everything that was wrong about the system.
Well, it's simply degrading and inhumane, that kind of treatment. So we hope that that's...
Mind you, Pauline, that the officers taking him up stopped to urinate because, he had a kidney problem, but that was okay, apparently.
Yeah. Okay, well, thank you for that. We've also got a video question by Kanisha Gumla Galawinku from the Galawinku Law and Justice Project.
My name is Kanisha Gumbola, and I am a young woman from Arnhem Land, which is located in the top end of Northern Territory. I am currently studying associate degree in legal studies at Charles Darwin University, as well as work as a community legal educator at Naja. I come from a large community in northeast Arnhem Land called Galunko in Elko Island. With my work, I travel with the Naja team to Galunko on the weeks prior to Bush Court and the week of court. We help educate Yolngu people and different community services about law. We also help support the elders group to engage with the legal system and Bush courts in the community. We help write letters that are signed by elders for clients attending the Bush courts. This work leads to people receiving sentences on community and in ways supported by community rather than prison in Darwin. Elders give their time to support this and to support family. The Royal Commission into the Detention and Protection of Children in the Northern Territory emphasized the empowerment of Aboriginal people. This includes youth justice and also areas like child protection. The community elders of Galunko want to reassert their power and authority as decision makers as it relates to our people. We have been calling for this for a long time. My question is, what can be done to achieve this?
It's nice to hear those birds in the background. Who'd like to start with that? Mick Gooda, would you like to respond first?
Oh, look, we know that what that young lady just said is true, what the elders are telling her. We know that when kids are engaged in culture, there are far better outcomes. I just can't understand why people don't listen. You know, it's this thing that we try to get people, we put the evidence in front of them, we show them what does. It's the Aboriginal community doing all the heavy lifting here with our supporters, of course. But we're the ones going to government all the time with the evidence, with the answers, but they just don't listen. And I go back to my first response today was I just want to see our mob listen to that young lady and what the elders are telling her. We got told exactly the same thing. Give us our power back and we can fix this problem. So I'm just saying, hopefully after this election in the Northern Territory, we can actually get someone who really wants to set some standards in Australia and how to deal with this. It's a great opportunity.
Thanks very much. David, would you like to respond next?
Yes, sure. Look, Pauline, I've had the great privilege of working with elders in community courts in the Northern Territory many years ago, not just in Ali Curran, Yudamu, Largemanu, and in Katherine. Community courts are absolutely the way to go in addressing the question. Community courts provide, and the role that elders play as part of that process, provide not just great strength and guidance and information to assist the court in its decision making, but also the great thing is actually seeing the pride of Aboriginal children when they're there before the elders of their community. So community courts are really the great opportunity, and it is also part of the recommendations in the draft Aboriginal Justice Agreement for the Northern Territory. So really community courts are the way to go. One of the key issues in the past why we don't have community courts today is the commitment to funding. We need government to fund these community courts and the supports and the services. And it's actually, as Kenesha had said, the giving of the time of Aboriginal people to do that. They need the time and the supports to be fully part of that process.
And translators.
Interpreters and in having court proceedings in one's own language is so fantastic.
Yep.
Yes.
Olga, what's your response?
I think I find this conversation somewhat ironic, given that at one level you've got people in suburbs like Palmerston or in Alice Springs or elsewhere calling on Aboriginal people as parents to take responsibility for their kids in terms of their behaviour and offending and so on. And at the same time, we have Aboriginal people saying, we want to take responsibility, but somehow we don't ever seem to get this kind of aligned. I think there are different and alternative mechanisms that are possible that would both satisfy, I suppose, the demand and the expectation from the broader community, about kids and families being held responsible, but also within an Aboriginal context where Aboriginal people have the power to make decisions about what will happen to those children, what the consequences should be, and how reparation might be made. To me, I think that this is actually a bigger issue that needs to be taken up with any discussions around an agenda for treaty in the Northern Territory, because it seems to me that unless we've got some meaningful recognition of the legal rights and responsibilities and the political accommodation of Aboriginal people within the NT, then none of this will change. This is a white legal system developed out of British common law, managed and dominated and driven and controlled by non-Aboriginal people. So, you know, that shift of power and putting that decision-making and authority into the hands of Aboriginal people in a way that isn't sort of cursory or temporary, that it's there and it's embedded and it's sustainable with all of the resourcing and funding that's needed, is absolutely the way we need to go.
Thanks very much. I might stay with you for a moment, Olga Havnen. We've got a few questions from the audience. This one, I think, leads on from what you've said. Do the panellists see a link between the call in the Uluru Statement for a voice and self-determination and the resistance to this and the refusal of governments and administrators, decision makers and policy makers to make change, as there's so little control by First Nations community over how policies are made and executed?
I think whoever submitted the question absolutely hit the nail on the head. It's about power and control and who makes decisions. There's been an incredible reluctance on the part of governments, you know, nationally, domestically, even at the local level, to really engage with us in any sort of meaningful way. Until that shift is there, then it's going to be very difficult for us, and we will still be outside the system, you know, trying to persuade and cajole and encourage governments to change their approach. One would hope, coming off the back of that Uluru Statement, that perhaps some of the politicians and others will take heed of what the call was all about. And my question, I guess, back is, you know, why can't we make progress on it?
Thanks. David Woodruff, do you have a response to that question?
Oh, no, I agree absolutely with Olga. I think really we have to change. There are two Malaysas I think in the Northern Territory in Australia today. That is not just the apathy of government, but also the ignorance of the evidence and the voices of Aboriginal people. The voices of Aboriginal people need to be heard in this discussion.
Thanks. And Mick Gooda, what about you?
The Uluru Statement is just another example of how governments work, and they try to take the moral high ground. I was in the Northern Territory when the intervention started, and if you didn't present your children to be checked when that was all starting to happen, you had something to hide, or if you wanted to fight the intervention, you supported child abuse. So they captured the moral high ground. In the Uluru Statement, they've also captured the moral high ground by saying, oh, it's another chamber of parliament. And I said in numerous interviews, I haven't heard an Aboriginal or Torres Strait Islander person call the voice to parliament a third chamber. It's always the politicians that call that so they can reach for the moral high ground and try to reduce the authority of parliament. And that's how they scare people. And they scare them all the time by capturing the moral high ground. And if you fight against it, you're sort of against motherhood and apple pies or whatever, because that's the way they frame it. And the Uluru Statement is exactly the same as what they did in the intervention. You don't support the intervention, therefore you support child abuse.
Mm-hmm.
We just got to break that nexus, and we need people out there to say, you know, I remember take my daughter, she was 7 years old, up to Garma that year, and when I said, I'm not presenting my child, she's coming up there, the next day, that's when Woodruff come out and said, if parents don't present their children for these tests or whatever, they must have something to hide. So, you know, it just beggars belief how they say it all the time, and it also beggars belief how that keeps on working with the community.
Yeah. Look, we've got another very good question from the audience. Bringing it back to tin tax, I suppose, and probably I'll ask David Woodruff to respond first. young people who are kept in remand for long periods remain there because there's no safe place to bail them. This seems like another failure of the child protection system or government housing system. What can be done for young people in this situation?
It's all. I think the additional issue is really looking at our bail laws. Our bail laws are too tough. The presumptions against bail for children, but also the lack of the support services and the alternative accommodation. We have to really provide those places, and working with Aboriginal communities. Some of the great work that has been done by law and justice groups is providing those alternatives and kinship mapping of communities about where children can go to and who they can stay with through our child protection system. All too often we see exactly around that crossover of children who end up in care and residential care in places like that, and you know who self-place themselves and running away and ending up in the justice system. Really, we have to be looking about the family supports and the structures in communities that children can stay with and be bailed to.
Thanks very much. Olga, Havnen and Mick Gooda, do you have anything to say in relation to that issue?
Just quickly, I would point out that I think about 60% of the children in youth detention here in the Northern Territory are also within the child protection system. So if the bail laws are structured in such a way that they deem that there's no safe or suitable place for those kids to go, I'd have to ask, well, why not? And what is the Minister for Children and Families doing about making sure they do have a safe place to go?
Thank you. Mick Gooda, anything to add?
Just that we looked at it, at the bail stuff, and the conditions of bail are just horrendous. You got families being constantly woken up during the night so police can check and see if they're keeping a curfew. And I can't remember which state it was. I think it was New South Wales, where they just changed a couple of words in the curfew condition to say you can't be at a particular place between the hours of this, not that you've got to be home. And in New South Wales, to a certain extent, they solved that problem about knocking on doors in the middle of the night. And I think you've got to look at that as well, because it's almost, those conditions just set kids up to fail. And when they fail, they're going to be put back into be sentenced for even just breaking their bail conditions.
So, Mick, sorry to interrupt, but I mean, what do you think the child protection system should be doing when, as I say, 60% of the kids in Dondale are coming straight out of that system?
Well,
this isn't a problem with families. I mean, the kids have already been removed.
The pipeline, yeah, we thought about how do you do the child protection system? How do you design the perfect one? Well, the problem in Australia and around the world is you design a perfect, you can go close, but the minute there's a tragic incident, you have a review and then you end up with another child protection system. And the thing we know is that the child protection system does damage to our kids. It does damage to all kids. So there's got to be, we've got to start thinking about what are the compelling reasons. I can give you any number of reasons why we should keep kids with family. The evidence tells us the best interest of the child is to be kept with families. And it's the same as what you said when you introduced this webinar, that prison should be the thing of last resort, for option of last resort. But it seems to me, and it seems to everyone, that removing kids is the option of first resort, not last. Yep. And we disregard all the responsibilities families have. Like we interviewed people, they gave evidence that they didn't even understand the extended family structures in community, in families, about dad might be missing an action, but there's another two mothers and there's a couple other fathers there that would take responsibility for those children. And they just couldn't even be bothered doing that. And that's why we end up with kids in the child protection. So what we've got to do is follow the health model, and that's what we said. It's early intervention, it's a public health model of putting work at the primary end, and that's supporting families that are in distress. And one of the things we're doing in Queensland right now is trying to work out what are the indications of a family in distress, so you can actually get in there with those early interventions rather than wait till it turns into a catastrophe and kids are going to be removed. But, you know, again, we looked at a trial in Alice Springs during the Royal Commission about family conferencing. Everyone said it just worked. but the government at the time said it was too expensive, and next minute we're spending something like $24 million a year on what we call eBaying kids into these daycare places overnight. 24 million bucks, gone from nothing to 24 million bucks almost immediately. But family conferencing was a bit too expensive because it would probably work.
Yeah. Good, thanks for that. Look, we've also had a question from Cassandra Griffiths, coordinator, Top End Northern Territory Community Visitor Program. She asks what progress has been made on access to trauma-informed mental health care and treatment for children in detention in the Northern Territory. Olga Havnen, is that one for you? Have you got comments to make there?
It's a really good question. Just to put this into some sort of context, Danla Dilba, as a result of a settlement from some litigation, is now with Congress working and providing primary healthcare services in both Don Dale and the Alice Springs Youth Detention Centre. We've only taken up that role since the 1st of July, and whilst the funding for delivery of those services is quite modest, we would hope that over time we would be able to expand those services to include a lot more of the genuine therapeutic sort of supports that kids need, but more importantly be able to get some of these assessments done first so that we can get those plans developed. But it seems to me to be quite at odds that, as I say, so many of the children being from child protection have to wait till they get into Don Dale before you get access to the service. It's quite ridiculous.
Thanks very much. There's another question here. Do we need law reform around laws such as mandatory sentencing and Section 16AA of the Commonwealth Crimes Act, which prohibits courts from having regard to cultural practice when considering the seriousness of an offence? Maybe I'll address that to you, David Woodruff.
Absolutely. They two of the key things for the Northern Territory. In past election, I've been a lawyer for 20 odd years. Mandatory sentencing has been in the Northern Territory for some 22 years. Each successive government has maintained an unjust system, an unfair system, and a system of mandatory sentencing laws that heavily impact primarily on Aboriginal people and seeing them in prison. So we do need to have that reform. Mandatory sentencing is a must. It must be repealed. There's no ifs and buts. It has to go. Secondary, we also need to see the reform of the Crimes Act from the Commonwealth around Section 16AA about the importance of, as we've all talked about today, about the introduction of Aboriginal law and information that is put before the courts, not just in relation to bail, but also in relation to sentencing, and the rehabilitative effects of Aboriginal law that can occur. There's some great work that's happening in Victoria around experiential reports, or following the Canadian model of graduate reports. This is the type of information that needs to come before our courts, and particularly around youth justice.
Thanks very much. Look, I'm just mindful of the time, so I think we're going to have to wind up, but I'd like to once again thank our panellists, Mick Gooda, Olga Havnen and David Woodruff, as well as Malila May at the beginning. But some key takeaway points I think that we've been able to draw out of the discussion would include that incremental progress has been made, but we still need the serious and systemic changes, the transformative changes such as raising the age and replacing Don Dale as recommended by the Royal Commission. We've got to listen and engage with the Aboriginal community, elections or not, and support long-term embedded Aboriginal-led solutions. Aboriginal elders want to take responsibility for their kids, and we've got to re-empower and give power back to Aboriginal people. We need a genuine therapeutic approach. This is so easily discussed but rarely implemented. We need a youth justice system that meets the needs of children and their families wherever they are, centred around Aboriginal children. And let's look at the evidence of what happens and what does work to keep communities safe and to stop recidivism. There are alternative existing models to existing juvenile detention approaches, which are cheaper and more effective. Why don't we look at them? So I think that about sums up the main themes that have come out of this evening's discussions. We're very much indebted to our panellists, to our experts, and we hope that you've all found in this discussion a reflection of the important work that's being done by Aboriginal community controlled organisations across the Northern Territory, and a clarion call to all of us to continue that. And I'd like to highlight that the Law Council is very grateful for the expert guidance of the members of its Indigenous Incarceration Working Group in bringing together tonight's event. Many of its members have been intimately involved in the Royal Commission and keeping its findings and recommendations on the agenda. And I'd like to thank too the Law Society of the Northern Territory for its support in holding this event and its very strong commitment to progress in this fundamental area of importance. And finally, we'd like to run another event in this series, next time focusing on the Australian Law Reform Commission's Pathways to Justice report. And for those of you who'd like to stay in touch with that and hear about our forthcoming events, stay in touch with us through our social media handles or provide feedback through mail at lawcouncil.asn.au. But do stay in touch. Thank you once again to our panellists. Thank you all very much for your attendance. Good night.
Thanks.
Thank you.
All the best.
You too. Bye-bye.